Is the insanity defense viewed skeptically in criminal court? Have you ever wondered how the legal system views claims of insanity in criminal cases? The insanity defense is a complex topic that often raises eyebrows in courtrooms. While it can be a vital strategy for some defendants, it is generally met with skepticism. In fact, it is invoked in less than 1% of felony cases. Even when it is raised, success rates hover around 25% or less. This low usage and success rate show how cautious courts are when it comes to accepting claims of legal insanity. So, what exactly is the insanity defense? It asserts that a defendant was unable to understand the nature of their actions or distinguish right from wrong due to a severe mental illness at the time of the crime. Because this defense questions the defendant's criminal responsibility based on mental health issues, courts requiring strong evidence to support it. This often includes expert psychiatric testimony. Several factors contribute to the skepticism surrounding the insanity defense. First, there is a high burden of proof. Defendants must meet strict legal standards, such as the Monotone Rule. This rule requires proving that the defendant did not know what they were doing or that it was wrong. This can be very difficult to establish convincingly to a jury. Another factor is the public and judicial concern about potential abuse of the insanity defense. Many people worry that it could be used as a loophole to avoid punishment. However, studies show that actual abuse of this defense is rare. Mental health professionals are usually quite skilled at detecting when someone is faking illness. Even when a defendant successfully pleads insanity, the consequences can be severe. Instead of being released, they are often committed to mental health institutions for long periods. In some cases, this can be longer than a prison sentence would have been. This reality discourages frivolous use of the defense. Limited resources also play a role. Public defenders often have heavy caseloads and may lack the time or expertise to fully investigate or pursue an insanity defense. This defense requires specialized psychiatric evaluation and expert testimony, which can be challenging to obtain. From a criminal defense standpoint, while the insanity defense is tough to prove and viewed skeptically, it remains an important strategy. It helps ensure that defendants who genuinely suffer from severe mental illness receive appropriate treatment rather than punishment. Defense attorneys must carefully evaluate the facts and psychiatric evidence before pursuing this defense. An unsuccessful attempt can negatively impact plea bargaining and trial outcomes. In summary, the insanity defense is rare and challenging to succeed with, reflecting judicial caution and public skepticism. However, when applied correctly, it plays a critical role in balancing criminal justice with mental health considerations.